Good afternoon, morning, night, whatever time it is to you. Happy whatever day you're celebrating. Not legal advice. Like, subscribe, share. Is the hat on straight? I can't tell. I don't see out of my right eye, so sometimes it's not exactly straight. That's the way it goes. Make sure to let your animals watch these because my your animals will like it maybe even more than you do. I wanted to talk a little bit about the new brief that was filed today by FINRA in the appellate case that I was talking about or have been talking about. And we can go through that a little bit about the brief and what it says and where we're going to go from here. And in addition to that, before I start, I have a pun about amnesia, but I forgot how it goes. And last but not least, a friend of mine said he does not understand cloning. That makes two of us. Anyway, so today FINRA filed their brief, and this is the appellate brief. So, this, to put it in context, so Alpine is involved in litigation with FINRA, and this particular uh, proceeding currently involves an appeal of the denial of the injunction by the district court. So, at some point in time, and I'll go through a little history in a moment, but at some point in time, Alpine wanted to stop FINRA from moving forward to expel Alpine. They filed a lawsuit, then they went into court. They tried to get an injunction. Originally, it was denied. Then it was granted by the Court of Appeal. But this particular appeal is about whether the denial by the district court was proper. That's the issue here, and whether it was constitutes an abuse of discretion, which is an appellate term. And remember, an appellate case generally they're not litigating the facts; they're just litigating the law. That's kind of to put it in context. So, if at this point in time, if the court finds in favor of FINRA in the appeal, they would be able to go forward and try to expel Alpine right away. If the appellate court rules in favor of Alpine, then FINRA would either have to relitigate some of the enforcement actions, some of the discipline actions, go to federal court, have a receiver appointed, or take some other action. So that's kind of the the procedural status. And today, FINRA filed their brief. So that's what they filed. And their brief would be the respondent. It's called the respondent's brief. It's really the opposition brief. And then Alpine will get an opportunity to, and there may be others who jump in because there has been in the past, who will file uh, a reply brief or further friends of the court brief. So since the FINRA brief was filed today, I would expect Alpine's reply to be in about 30 days. And then the appellate court clerks and the judges would then review the paperwork, set it up for oral argument. I would expect oral argument probably be 60 to 120 days after the submission of the reply brief. And again, this is the opposition brief, respondent's brief, not the reply brief. So the reply brief about 30 days, then oral argument probably 60 to 120 days after. So that's kind of the time frame. Now I'm going to give you like the factual history, and this is kind of referenced in the brief also because the brief is 77 pages. So I have looked through it today, but I haven't studied it. But this is kind of on my first blush through it, and I looked at a couple other cases that are cited in it. So I decided to kind of give that to you. So recall from, and again, GTII Alpine. People think that GTI is connected to finger motion, and some people believe that if Alpine is disciplined or loses their ability to function business, that will trigger a short squeeze, etc. So that's kind of where this starts. in the bigger picture, there's a challenge to the constitutionality of both FINRA and the SEC, and that's the bigger picture. So now let's go factual. So recall in 1983, I think it's 1983, Alpine gets started, and through about 2022, it and Scottsdale were penalized for various misconduct, I think over 40 times for various types of misconduct. So that's up through 2022. What I learned, and they have brought numerous lawsuits, them being either Alpine, Scottsdale, or somebody connected to both, have filed maybe 10 different federal lawsuits against FINRA, and nothing, they haven't prevailed in any of them, as far as I know, and they've lost in most of them. So that's their status. So they haven't been successful, but they've certainly litigated. And one of the actions they brought was in 2017. They challenged an action that was brought by the SEC. And what I found about this that was interesting was we've had discussions about the Grand Cayman Islands, about Alpine and maybe Cayman Trading Limited, trading offshore, and what that means and who they're dealing with. They're dealing with trading outside the United States. So we found that interesting, and I think I did a video on it. I'm sure I did a video on it a few weeks ago. So we're concerned about how the business is being conducted, whether taxes are being collected, et cetera. So when I was reading the brief, I stumbled upon this, that in 2017, the SEC went after Alpine because of numerous, being thousands of violations in their SAR, their suspicious activity reports. In other words, I think the amount is $5,000, but if there's any kind of transaction involving $5,000 or more that the broker dealer suspects might be criminal, might be used for criminal activity, or in which they're involved, etc., they have a duty to provide something called the suspicious activity report, an SAR. And in this case, from 2011 through 2017, Alpine, shockingly, didn't provide their SARs, or whatever they provided were not complete or attempted to obscure potential activity. And recall that this particular law was placed in after 9/11 to prevent terrorists from gaining access to large amounts of cash. Also, it's obviously used for, or at least used to prevent tax evasion and those type of things. All the things that we claim that occur in naked shorting or counterfeiting shorting. So in 2017, the SEC brought an enforcement action that went up on appeal in 2019 and was decided in 2019. And it was determined that, and if you recall, I'll get to that point. It was determined that that Alpine had violated the regulations involving banking secrecy thousands of times, had not given complete or accurate information, had obscured, etc. The appeal upheld the verdict of the district court, and a large fine, I believe it's a large fine, a fine of $12 million was imposed against Alpine. Now, if Alpine had actually a fine of $12 million, I don't see how they're still in business. So I don't know who paid that fine, if it was paid, etc. But that would be a large fine for Alpine. And again, what's interesting is the concern about money laundering or naked shorting, and the fact here that they didn't file the reports. And that goes along with the activities of the Alpine crew in the Caymans relating to foreign trading. So certainly, listen, we may have to put out a SAR on Alpine, because this really sounds, just this particular incident in 2017, 2019 sounds suspect. And are they laundering money? I mean, that's the question. They were told not to engage in those transactions after 2019. Are they? Are they not? Are they now good guys? What would you think? So So that's kind of the factual background. And then obviously, in 2022 for stealing approximately $54 million, for overcharging, for converting securities, for improper withdrawals. In March of 2022, they were ordered expelled, and a cease and desist order was issued. And then we got to the point of the expedited expulsion, etc., which brought us up to date, and the appeal brief. So the basic arguments in the appeal brief, and it's 77 pages, but this is basically summing it up, that because FINRA is a private company, they're not subject to all the constitutional protections. And unless they were a government officer, as it's defined, or in essence were working as a government officer, that they're not obligated under the constitutional provisions and arguments that are made by Alpine. And beyond that, since they're not an officer of the court, they're not governed by that. They're not subject to the appointments clause, the non-delegation clause. They didn't really talk about the Fifth Amendment. So, in other words, can their proceedings be unfair? Do they have to at least be fair, subject to the constitutional requirements? What about the Fifth Amendment right against self-incrimination? What about the Seventh Amendment right to jury trial? Those weren't really addressed in FINRA's brief. And in fact, they did cite one occasion where somebody was a private company, but they can be set up by the government, controlled by the government. In that case, they could be considered to be a state actor, and they might be subject to the constitutional provisions. And that one, they cited Amtrak as such a entity that was set up by the government, kind of regulated by the government, etc. They're distinguishing that from FINRA, which is purely private. And most importantly, they say, and I think this is the part which I find interesting and questionable, they say they are closely monitored by the SEC. In effect, since the government is closely monitoring them, then they are not, in effect, a state actor. The government is in effect, utilizing its own independent judgment to make those decisions. So the argument again is they're not a state actor, and their actions shouldn't be attributable to them. And their other concern is that if the ruling came down that that it would open the floodgates and everybody would sue FINRA and go after them and attack them. Maybe that's possible. That really wouldn't be a reason for, if you had a illegal law or a violative law or any other proceeding, the fact that it would open the floodgates to further litigation really is not a point to consider. The other point, and I've raised this before, that FINRA asserted was the equities. In effect, that above all, what we're trying to do here is protect the public in light of all the violations that Alpine has engaged in over the years. Again, I said, notwithstanding the violations of Banking and Secrecy Act and all the 40 actions before that, and then the expulsion for the $54 million ripoff after that, there were 35,000 additional violations. So FINRA is saying, and I'm saying much more strongly, that we need protection from Alpine. No, the injunction should not have been granted as the district court ruled, and that's where it should lie. So that's the argument made by FINRA. It'll be interesting to see what the reply brief is. There is certainly a movement afoot to limit FINRA's authority. The question is Alpine so dirty that the court being the Supreme Court, won't touch them? And I don't know, because Alpine is filthy. Just in light of, remember, there was also an accusation of a sex crime at Alpine. So we got that. We got all the misconduct, etc. So FINRA is saying basically not a state actor, so we're not responsible. We're subject to the SEC authority and sign off. So tough. And Alpine is saying it's unconstitutional. It's a violation of the Appointments Clause, the Constitution. There are some other due process arguments, etc. So that's where it brings us today. We'll see what happens in the reply brief, which is going to be in 30 days, it gives us more evidence that Alpine needs to be stopped because they're dirty. And I think somebody should be looking into their conduct, especially as it relates to the banking misconduct that they lost on appeal. Anyway, that's my quick take on this tonight. Hope that brought you up to date. There'll be a response. I don't think it changes my view. Again, I think it's very possible the court could deny the appeal, but eventually rule in favor of Alpine as to the due process arguments. And just to explain, the way it's supposed to work is the courts are supposed to decide as narrow as possible. So if in the injunction issue, if they could rule just on that limited injunction issue without getting into greater constitutional issues, they will do that. So they could do that, or else they could just say that FINRA or the SEC don't have authority, et cetera, something along those lines. Anyway, I will certainly keep you apprised. Hope this makes sense. I know this is kind of long. Be well, take care, have a great weekend, and be well. Yes, I do.